The event, as you all know, is Islamic legal reform, family law in contemporary North Africa. And as some of you learned in my class, Muslim family law covers a range of what I would call deeply personal or private issues, which at the same time have really vast public and socioeconomic ramifications. So there are issues such as polygamy, child marriage, custody, divorce, inheritance, the division of labor within families. All of these come under this very broad umbrella of Islamic family law. And in recent decades, we have what I would call sensational, or let's say sensationalized stories of violations of individual women's rights and honor crimes in majority Muslim countries that have called international issues to what is normally a very arcane topic, which is Islamic family law. And also in recent decades, and perhaps within the past decade or so since the Arab Spring, we have a significant rise in demands for law in the areas of legal prescriptions as they relate to families and women. And in all of these discussions and discourses, there are some basic questions that seem to loom very large. One of them is it possible to reconcile demands for gender equity and equality as expressed in secular democratic contexts with religious laws? It's a very basic and big question. And another one is, in the face of what seems to be really entrenched injustices against women in many Muslim societies, why do so many Muslim men and Muslim women persist in their belief that Islamic prescriptions are the best guarantor of rights or anything that resembles equality for women? Obviously, we're not going to solve those really big questions or even come close to answering them here, but I think it's very useful and invaluable to listen to expert voices. And towards that end, this panel brings together authorities in the areas of Islamic legal reform and gender studies and the study of Islam and democracy to shed some light on this topic of Islamic family law in North African context. So I'll go ahead and introduce the speakers in alphabetical order by last name. The first panelist is Professor Khaled Abou El Fadl, who is the Omar and Azmeralda Alfi Distinguished Professor in Islamic Law at the UCLA School of Law. He teaches international human rights, Islamic jurisprudence, national security law, Islam and human rights, and political crimes and legal systems. Among his many honors and distinctions, Professor Abou El Fadl was awarded the University of Oslo Human Rights Award in 2007 and named a Carnegie Scholar in Islamic Law in 2005. He's the author of several books and numerous articles. His monographs include Authoritative and Authoritarian in Islamic Discourses, Rebellion and Violence in Islamic Law, Speaking in God's Name, Islamic Law, Authority, and Women, The Great Theft, Wrestling Islam from the Extremists, and most recently, Reasoning with God, Reclaiming Sharia in the Modern Age. Professor Abou El Fadl's contributions are especially welcome today because of his extensive scholarship on Islamic legal reform, especially in light of contemporary debates on universal human rights. Hakima Fassi Fihri is a professor at the International University of Rabat's School of Law. She also serves as Director of International Relations and Partnerships at UIR, and she's a member of its managing board. She's a graduate of Rabat University School of Law and holds a master's degree in European law from the University Pierre Mendès, France. France. Right. She conducts research, publishes, and teaches on women's rights in Morocco, and particularly on readings of the Mudawana, or Moroccan Family Code legislation. These prescriptions are based on Islamic law, and they have profound implications for discussions about women's roles gender equality and women's empowerment in Morocco and North Africa, generally speaking, and she's going to discuss some of these issues in her talk today. And lastly, our ghost panelist is Redwan Masmoudi. He is the founder and president of the Center for the Study of Islam and Democracy, which is a DC-based think tank dedicated to promoting democracy in the Muslim world. Dr. Masmoudi is also an advisor to Sheikh Rashid Ghannouchi on U.S.-Tunisian relations. He has written and published several articles and papers on topics of democracy, diversity, human rights, and tolerance in Islam. Because he's traveling, he really wanted to be with us here, and he was originally going to Skype in, but we realized that the time difference between Tunisia and LA makes that impossible. It's something like 3 a.m. there right now. So he very kindly pre-recorded his presentation with me last week, and I'm going to show it here. It's, his insights are really useful for helping us round out the picture. Before turning over the floor to our honored guests, I want to thank our co-sponsors. This event would definitely not have been possible without the generosity of the Muslim Reform Institute of Los Angeles, which has set up a fund to support these types of public events through the UCLA Islamic Studies program, the UCLA Center for Near Eastern Studies, and the UCLA School of Law, International and Comparative Law program. Just briefly, before starting, each speaker will speak for about 15 to 20 minutes, and we will open up the floor for discussions. I know some of you may have to leave. Please, you may have to leave early. Please, don't be disruptive in your leaving. If you have to leave, please leave in between one of the talks. So please join me first in welcoming Hakima Fessy.
Thanks. So, the microphone is on. It is not on.
Not shown. So you'll probably need to bring it to switch. Okay.
Yeah.
Testing.
Okay. I guess it's working. Yeah. Thank you so much for having me. Hello, everyone. Thank you for being here. So, this is a full house. It's a wonderful opportunity for me to come all the way from Rabat, Morocco, my hometown and my home country, to speak to you today about quite an important matter and a topic on Islamic legal reform in the context of family law. And I'm here to address actually the Moroccan law. This is exactly the purpose of this talk is really to give you some background on the family law reforms in Morocco within the past decades, but in independent Morocco since 1956. So just in a nutshell, Morocco was under the French protectorate between 1912 and 1956, and it was officially independent in 1956. As per the Moroccan constitution, the last one was actually implemented in 2011, the same year of the Arab Spring, and Islam is the religion of the state, and it was always the case even in the previous versions of the constitutions of Morocco since its independence. And the king is not only a political leader and the head of the state, but is also a religious or spiritual leader, commander of the faithful. Is really, this is the official term used for that status. And it's he is the commander of the faithful, not only the Muslim believers, but all the faithful, which means, and we don't outline that enough sometimes about Morocco, there is also the Jewish Moroccan community. This being said, the Mudawana, the Moroccan family code, actually is a code that applies to Muslim Moroccans, because Jewish Moroccans have their own family code, family text, from the Hebraic religion and the Hebraic rules for Jewish communities. So Mudawana basically was the first version of the family code was in 1958, so really right after the independence of Morocco. Then there was, so you can imagine, from 58 to 93, nothing ever happened on this text in terms of reforms. That means that it's because actually for Moroccans, this text, the family code, was really perceived for so many years and decades as somehow sacred. Why is that? It's because actually the main source of family law is actually Islamic law. It's Sharia, and which is why in the perceptions of the people you cannot simply, touch this text. The family code was seen, because it's not the case anymore, kind of sacred text. And in 1993, there was the first minor, really very small, very tiny reform of the Mudawana, but symbolically it was huge, because it was really addressing a reform on this text which never knew any kind of reform before that date. And we had to wait until 2004, where actually the major reform of the Mudawana took place. And that's what I'm addressing now, because it's worth listing and seeing together today what happened in this reform. What was the big change? So the big change is set forth right here. It's first of all a new concept, the concept of co-responsibility within the household between men and women. That means that actually there's, I don't know, it's maybe too close, right? I think I'm gonna. So this idea of co-responsibility of both the wife and the husband within the household, and addressing for the first time the idea of equality between husbands and wives within the family. And this is very new. That's really conceptual and very new and very innovative. The second point was actually to abandon or waive the Quranic notion of women's obedience or ta'a to the husband. This was clearly, you can check and see the previous versions of Mudawana, and you can see that the term ta'a used in the provisions, whereas since 2004, that was really, it's not a notion that you can find in the new or the recent, the reform, the new text. Marital tutelage removal, it's actually about adult women. Before, in the previous times, they had to actually have or get the approval and the permission of their tutor or guardian, wali, what we call wilaya, to grant them permission to get married and even co-sign with them their marriage contracts. Since 2004, this is no longer required. An adult woman, actually, a Moroccan adult woman, Muslim woman, can actually get married. Basically, that means also or implies that she can do it without the consent of her father, her guardian or her tutor, because this is not anymore the case, and she, if she has more than 18 years old, she no longer needs that to marry. Also, the age of marriage, there was a change. The change was for girls, because for men, it did not change anything. It was already 18-year-old as the minimum age of for marriage in Morocco. And for girls, it was 15, and it actually changed to 18. So it's the same now, 18 years old for girls and for boys to get married. And we have, of course, we'll see later that we have issues on the marriage of minors. Quite a serious issue on that, especially in rural areas. Polygamy is not banned in Morocco, so it's really still in force, but it was actually through the new text of the Mudawana since 2004, it's actually the judge who can authorize the husband to take a second spouse or not, based on several criteria which are quite clear. Among them, you find, to guarantee equality between the different households, financially speaking, but not only that. And actually, I add this because this is a prerogative that women always had, even in the past, but they don't use it much. It's that at any time when they get married, they can insert actually a provision in their marriage contract to actually prevent the husband to take any other spouse during their marriage. That's always a possibility, but alas, it's not actually used that much, that often. Divorce, the most important thing that was actually the newest, very new, very innovative again for the Moroccan society was the shiqaq divorce. What we call shiqaq divorce is actually to give the right to women, to Moroccan women, to initiate the proceedings of divorce without giving any argument on that. They don't have any more to explain that they are victims of violence, or they have, because in the past there was a very specific list of motives that they could, or they were supposed to use to obtain the divorce from the judge. They couldn't ask for divorce otherwise than asking divorce to their husbands. If the husbands refused, then to the judge according to a list of motives. In that case, they are freed from that. The shiqaq allows, it's a new procedure allowing any woman to really go in front of the judge and explain that, okay, she wants to get a divorce, and she gets it. She only needs to go through a certain procedure. So this is really very new as well, as the slide says, and the proceedings are now subject to the judge supervision, clearly, of course. Judges, so here I have a slide for you on the obstacles or challenges of this law, because as you can imagine, it's never easy to implement a new law, especially regarding family, which is seen as somehow also sacred in Muslim societies, or it's the ultimate refuge for the values of a society, etc. So family is really, I think, in every society seen as the first cell of the broader society. And we noticed, and I mentioned it earlier, that's really an issue in the law enforcement, because this reform actually is not yet giving the option to minor girls to escape the situation that they're encountering too often still in Morocco, especially in rural areas, because actually the law is clear when it says that in only exceptional circumstances the judge can allow a minor, boy or girl, to get married. But actually the statistics show that the number of people who are, of minors who are allowed by judges to get married is really very, very high, especially regarding girls, minor girls' marriages. And this is really a serious issue again, because it addresses as well the idea of forcing these women, these minor girls to get married. We can imagine that a 16-year-old or a 14-year-old sometimes can actually get married and be involved in a marital status probably without her full consent, or not even being aware of what marriage is. So this issue is addressed clearly in Morocco nowadays. And judge training is also another, it's not an obstacle, but it's a question that is raised. And efforts are being made by the government of Morocco and the school of, the judge school that trains, the state school which actually trains judges. Efforts are made in the training of judges to be able to comprehend this new law and to be able to implement it according to the spirit of this new law, because it has a spirit, the spirit of equality and the spirit of opening, and also to train more women judges, because the number of women judges in Morocco is still quite low. Although some testimonials show, very interestingly, that having a woman judge dealing with a case of family, divorce or custody or anything, does not necessarily guarantee that she will be defending the women's, women's rights necessarily. It's quite a paradox, but it was. We have testimonials on situations in which you are. It's quite surprising, but it's complex. Sometimes, mentality resistance, of course, is another challenge because the paradox, and there is another paradox in the MENA region in general and in Morocco definitely. Progressive laws are developing in so many areas and at so many levels in Morocco. For instance, in political area or business, gender equality is there. In Morocco, it is the case. There is no issues in terms of law. I'm a lawyer and I'm addressing here really the legal perspective. I'm not talking here about the glass ceiling in business or in the careers of women. That's another story. I'm talking really about, as far as laws are concerned, in business and politics, men and women in Morocco are equals, but with regards to family structure and to women's rights, the mindsets start being quite resistant, and mostly on the ground of either patriarchal attitudes or sometimes, and quite often as well, religious arguments which are actually quite distorted, and people think that they know religion, but they don't know exactly what it's all about. And we say, scholars and at the university and people, when we talk to our students, and everybody's talking about religion and about, Quran, everything, and they think they know because they heard. Whereas you need to study that. That's one of the most complex matters or disciplines to study, and you know it very well because here we are gathered around Islamic studies, etc., and we know how complex it is. So the current challenge in Morocco, and I really wanted to address that as well, it's a debate now taking place within the society. It's not, it hasn't reached the parliament or anything at this point, but the society is addressing that, media is addressing that. This year and last year, it started a couple of years ago. And with really quite an intensive or intense rhythm and dynamics on this year. So equity between men and women in inheritance is really addressed right now because it has been considered as a taboo subject before. Again, on the ground that you cannot talk about, equity or equality in inheritance because religion is clear. This is what everybody thinks or will tell you when you talk to people in the Muslim world and among all categories at every age or every level. So there was a multidisciplinary collective book on women inheritance in Morocco released last year by several Moroccan scholars, and it was quite a pioneering book right here on this topic, addressing from many perspectives, the legal perspective, sociology, anthropology, theology, of course, because we need more than ever specialists and experts on ulama. The ulama, are the theologists who are actually, they have an authority, a religious authority in the Islamic world, and they could speak and explain in this book what are all the questions at stake. So on March 2018, it was a few months ago, there was a petition released online by a few people, scholars and activists and people from every sphere, for the repeal of one specific, actually, very specific idea on the inheritance that we call the ta'sib. And ta'sib in Islam, of course, perhaps you know what it is, otherwise it's coming in the next slide. And on this specific point, it did not address anything else. The petition was clear, and it addressed that point regarding ta'sib, creating an unprecedented debate, actually, and quite a massive reaction in Morocco, as you can imagine, in social media as well, press, etc. So the petition's argument was, according to Morocco's inheritance law, and not only Morocco, because in Tunisia, the ta'sib rule changed. The only place it changed, to my knowledge, I may be wrong on that, but I think I'm quite, that happens all the time, but it's okay. Okay, right here. So, men are universal heirs, meaning they have access to the full inheritance of their parents, whereas women inherit fixed parts, fard, and cannot receive the totality of the inheritance without the participation of at least one male relative to divide the shares. So accordingly, there's a lot of text, but it's really a matter of, it's quite, and that's, by the way, my last point I'm addressing, it's about inheritance. Women or girls who do not have a brother, one of their parents passed, and they are only siblings, girl siblings, no brother, they have to share, actually, the inheritance of the deceased parent with the closest male relative of the deceased. Could be the brother of the deceased, the nephew of the deceased, etc. Or with the distant male relatives at times. So if inheritance by ta'sib was, of course, I say of course, perhaps not that obvious to everyone, but historically speaking, it came from a situation, and it came from a context where it was fair to do so. In a tribal system of the time, where men not only took charge of their wives and closest female vulnerable relatives, but also had the responsibility to protect and vouch for their clan. And this is no longer the case. Moroccan families today are, as in many countries outside Morocco, I mean, nowadays, what we call nuclear families. So Moroccan families today are usually nuclear, limited to parents and their children. So women are often involved in taking care of the needs of their families, and these statistics are really interesting, and they speak for themselves, because we have these official numbers from the HCP, which is the Moroccan State Authority for Statistics. 20% of households in Morocco are supported exclusively by women, 20%, and this level, this rate is increasing. And an increasing number of women financially contribute already to the household or help their husbands. In addition, the number of women fending for themselves, they're single, unmarried, or divorced, widowed, widow without children, has also increased significantly. So in the current social context that I just mentioned, the question is asked, what do we do? This rule of ta'sib has consequently become unfair. The uncles do not take care anymore of their nieces, nor the cousins of their cousin females, nor do the men generally take care of the distant females of their families, even if they are alone or if they are poor. So how can we justify? That's the question of the whole purpose, actually, is to ask this question. How can we justify that relatives or distant relatives of a deceased person who did not leave a son share the inheritance with the orphan daughters, see, without in any way taking neither material nor moral responsibility towards them? Why maintain in the Moroccan law a rule that not only has no longer any social justification, but also, say, so many Islamic scholars, has no Quranic background? Ta'sib, because there is the other rule, the equality of shares, or inequality of shares between brothers and sisters. This verse, we all know it for those who are familiar with it. I'm talking here about ta'sib. Ta'sib is another aspect of inheritance laws. So ta'sib, on the contrary, we can say that it goes against the principle of al-adl, of justice, which actually are mentioned in the Quran. And it doesn't go neither in the sense of its purposes or maqasid. The above mentioned petition received quite a positive welcome by thousands of people. Well, 700 signatures in total is not significant, but symbolically it raised, actually it helped really raise the subject in the public sphere, which is why it was actually notable, which is why I am mentioning it. So for the first time, the debate within the Moroccan society on such essential topic is on. And perhaps, I don't know how I'm doing with time, but... Oh, you left your clock. Okay. I want to be just... Okay, so arguments, it's just my conclusion actually. Arguments to go further, how can we go further? How can we implement gender equality, or at least, the equity between genders in a Muslim country such as Morocco, and it applies to other countries as well. Although Islam is the religion of the state in the Moroccan constitution, this does not mean that laws in Morocco are based exclusively on Sharia. In fact, the majority of laws in Morocco are based on other sources, such as the jurisprudence, customs, French civil law. In the civil law in Morocco, it's the French Code Napoleon. Customs, I said, doctrine, international treaties such as CEDAW, mentioned this morning, and I'm mentioning it right now also. Another argument is that the Constitution of 2011 addressed for the first time in its Article 19, and really for the first time in Moroccan history, the equality in rights between men and women, between Moroccan citizens, men and women. Therefore, Morocco can adopt laws which are compliant with simply the constitutional principle that I just mentioned in Article 19 on gender equality. Another important text or legal background, again, I'm, as you can see, focusing on legal aspects. The Moroccan government did ratify the CEDAW. It's an international treaty on discriminations against women. And it weighed in 2008, actually, some reservations that the Moroccan government at the time had made on it. Therefore, all the discriminatory measures still present in the family code, such as the marriage of minors I mentioned earlier, or the authorization of polygamy, or the inequality in inheritance, can be changed as they are not compliant clearly with CEDAW prescriptions or provisions. And one of the biggest challenges for gender equality is also changing the mindsets and changing the mentalities, and this takes much longer. How do we do that? It applies to all countries in the world, including in the US or France or any other place. Mindsets are really hard to change, and it implies to raise awareness among boys and girls through the education system, from their young school ages, to make them really subscribe to this idea of, or principle of equality, so they can start promoting it again. And to end that, many scholars and activists and political leaders speak out the argument that Islam is not, and you said it earlier also, Asma, in your introduction, is not an obstacle to fair reforms. That's not true to say that. People who say that who say that Islam is the obstacle to fair reforms. Well, many people are actually, and experts and people from the field are saying that Islam is not the obstacle to fair reforms, and that mentality resistance and patriarchal attitudes and patriarchal readings of the religious texts remain the main source of resistance to women's empowerment and gender equality in Morocco. So the quote, I said it earlier, and I'm glad to repeat that quote to you this evening, is by a professor, a Moroccan professor in the University of Fez, and she authored so many books on these matters, gender studies in general, women are increasingly making the argument that they have been deliberately excluded from a full role in society, not because Islam prescribed it, but because Islam was revealed in a deeply patriarchal social context. So it all leads us back to adapting texts or situations, or laws, sorry, to situations and to contexts, if we want the laws to be fair. So that's, I hope I'm over. Thank you.
Thank you, everybody. And I'm sorry that I will not be able to join you for this wonderful conference that you are holding at UCLA. The topic is really interesting and fascinating. And but unfortunately, you're doing it at the time when I will be in Tunis, and it will be 4 a.m. in Tunis, so I'll be fast asleep at that time. It will be very hard for me to join you, but I wish you a very successful conference. So I wanted to talk about Tunisia and where the family law stands in Tunisia. Tunisia, as you know, is part of North Africa, which is 99% Muslim. So Islam has always been and remains a very important and essential part of our identity in Tunisia, in Morocco, in Libya, in Algeria. All these countries are basically 99% Muslim, and Islam is really an important part of our culture, of our heritage, of traditions. We also believe in ijtihad, which I'm sure is a term that you're gonna hear a lot about in this conference and probably discuss it a lot, especially since you have Professor Khaled Abou El Fadl with you in the conference. And ijtihad basically means that we are open to a new interpretation of the texts. Even though in Islam, the Quran and the Sunnah of the Prophet and the sayings of the Prophet, they do not change, the interpretations of those verses of the Quran and the Sunnah, it can change, and it can change based on the changing conditions of the society, the needs of the priorities of the societies. So there are many, many factors that can allow scholars of Islam to change their opinions on many, many topics, because it's never black and white. It's always gray areas, and there is always room for interpretation and for what is the best for the community, what is best for the individual, the family, and the community. So, because we believe in ijtihad, we are not bound by the old interpretations of Islam. The scholars, the early scholars of Islam in the 1st, the 2nd, the 3rd century of Islam, they had many opinions, and those opinions are very much respected. And we have the Maliki madhab in North Africa. We are all Maliki today. But we do not feel that those interpretations are necessarily valid for the 21st century. We feel that if those same scholars were here today, they probably would have changed some of their opinions, because the conditions have changed and the needs of the society and the family have changed. So, as an example, immediately after we gained independence, so Tunisia gained independence from France in 1956, we passed a new personal status code. I think we did the first year, probably in 1957. It was considered, and is still considered, the most progressive personal status code in the whole Arab world, and maybe in the whole Islamic world. For example, it is the only one in the Arab world that bans polygamy. Since 1957, the law in Tunisia bans polygamy, even though polygamy was allowed and was permitted in the Quran and early Islam. We feel, and the Muslim scholars in Tunisia and also the politicians in Tunisia felt, that the conditions have changed and there is no more need for polygamy to be allowed, even though it was allowed before. This is an example of ijtihad that passed 60 years ago, and it was almost unanimously, because people believe that this is a new ijtihad, a new interpretation of the Islamic texts. That and in this day and age, we do not need polygamy, and therefore we can do without. Also, the personal status code gives a lot of rights to women, basically equal rights to women in everything, from school, work, to everything. All the rights that are given to men are basically given to women, with one exception, which is the heritage law, the inheritance law, which we will talk about later. So unfortunately, since independence in 1956, however, we have been ruled by authoritarian regimes. First, Bourguiba ruled Tunisia for about 30 years, and then Ben Ali ruled Tunisia for another 25 years. And because of that authoritarian nature of the regimes, corruption became a huge problem, and poverty, etc. And that is why we had a revolution at the end of 2010 and early 2011. People, especially young people, went down in the street and said, enough is enough, we want freedom and we want dignity. So after the revolution in early 2011, our first task was to write a new constitution for Tunisia, a democratic constitution for Tunisia. And we had we had about 3 years to discuss the new constitution. What kind of a democracy do we want to have in Tunisia? And in particular, the relationship of religion and politics, as you probably would understand, was a matter of contention between a lot of people. Because Tunisia, like all Arab countries, are divided almost 50-50 between conservative people, religious people, who think that Islam should be a way of life, should be guiding everything in life and in the society, including in politics. And then you have the secularists who think that no, Islam should be a personal matter, but does not interfere with the laws and does not have anything to do with public life or with the laws or with the constitution. So these debates took about 3 years, from 2011 until 2014. And I can tell you that there was a lot of discussions and negotiations to discuss this new constitution and to reach consensus. I remember, and I participated in hundreds and thousands of meetings, not only in the capital between politicians, but all over the country, in many small towns and villages all over the country. People were involved and really wanted to know what is in the constitution, how do we protect our rights, how do we make sure that we have freedom and we don't go back to dictatorship, because Tunisians have suffered a lot in those 50 or 60 years under Bourguiba and Ben Ali from dictatorship, and we were determined that we will not allow dictatorship again. So there were hundreds and thousands of meetings to discuss the constitution, to discuss many clauses in the constitution. And for example, just to give you an example, one clause in the constitution talks about freedom of religion and freedom of conscience. It states that any Tunisian can have any religion he or she wants, they can change their religion if they want to, and that the state will respect the freedom of every citizen to practice any religion he or she wants. Even though we are 99% Muslim, we wanted to guarantee that people have the freedom to choose their religion. And of course, this was not easy, this was very contentious, but I can tell you that we had a lot of discussions and literally tens and hundreds of seminars and conferences to discuss this particular clause as well as many other clauses until we reached a consensus, and this clause passed in the Constitution to respect the freedom of religion and freedom of conscience. So more recently, in the last year or year and a half, many people, including the president, said that we wanted to or needed to have equal inheritance law. They said, if our constitution says that there is equal rights for all citizens, including for men and women, then why do we have a law that says that in the inheritance law, the son inherits twice as much as the daughter. And that is what's in the Quran, because in the Quran, there are many, many verses that divide exactly the inheritance, how it should be divided between everybody in the family. And of course, for centuries and 1400 years, Muslims respected those laws in the Quran to the letter. But now their argument was, well, things have changed. That those laws passed 1400 years ago, and it was because the husband was expected to cover all the expenses, to pay for all the expenses of the family. And the wife was not expected, was not required to pay for anything of the costs of the family, of the supporting the family. So the half that she gets in the inheritance, that's for her to spend whatever she wants and however she wants, but she's not required to spend it on supporting or sustaining the family. So there were, again, in the past year and a half, a lot of discussions about this particular proposal. And they can tell you that even to this day, these discussions continue. There are many people who are opposed to this because it clearly is against something mentioned in the Quran, but there are also many people who are for it because they see it that it is more in line with modernity and equality between men and women, and that this thing that the inheritance laws that existed in the Quran, that the conditions have changed, and therefore we need to change the laws. And again, this debate is still ongoing. I can tell you that many of the religious scholars, the majority of religious scholars and religious imams in Tunisia are against this proposal. To me, what is really heartening is that they are able to express their opinions even in the mosques during Friday prayers, even though this proposal was submitted by the president to parliament. The majority of the imams, the religious leaders, are opposed to it, and they can say so publicly. So there is a very lively debate about this bill. However, we are not a theocracy. We do not have the imams and the religious scholars cannot decide the laws. It is only the parliament that decides the laws. And so now this law is being debated in parliament between the various parties. And I'm sure that they're going to work for a consensus. And most probably the consensus that is being discussed anyways is that every citizen will have to choose between two regimes. One regime says, okay, I want to apply the Quranic laws in terms of inheritance. After I die, I want my inheritance to be divided according to inheritance laws. Or I want to divide it according to 50-50 between my sons and my daughters, or he can decide any way he or she wants to divide the inheritance. So every citizen will have that option to choose which one he wants. And I think the only difference right now that remains is whether the default will be the 50-50 or the Quranic laws. In case the citizen does not go and does not register and specify how he wants his inheritance to be divided, which is used as the default. Is it still the Islamic laws, the Quranic laws, or is the 50-50? So this is probably now the only issue that remains to be discussed in Parliament and is being discussed, and I think in the next few months they will vote on it. So what I wanted to conclude with is in Tunisia we feel that we have a very, very important task, which is implementing and building first real democracy in the Arab world. Unfortunately, the Arab world is suffering from dictatorship, from tyrannical regimes and tyrannical rulers who impose their views and impose their opinions on everybody, sometimes in the name of religion and sometimes in the name of secularism, like Hafez al-Assad or Saddam Hussein or even Ben Ali. They are imposing their opinion not in the name of religion, but in the name of secular values that they think are needed. In Tunisia, our goal is to build the real democracy. The final word belongs to the people, We do not want a theocracy, but we do want a democracy for a Muslim country, for a population that is 99% Muslim. Of course, we have differences of opinions on that, on what that means, on what Islam means in the 21st century. But those differences of opinions have to be resolved by negotiations, by dialogue, and ultimately by voting in the parliament. And whichever has the majority, that's what becomes the law. So there are two articles in the Tunisian constitution, the new Tunisian constitution, which was passed in 2014. I want to bring your attention to them. The Article 1 says basically Tunisia is a republic whose language is is Arabic, and whose religion is Islam. So this is the first clause in the constitution. It defines Tunisia as a republic whose language is Arabic and whose religion is Islam. The second article, or the second clause in the constitution, says Tunisia is a civil state based on citizenship, the will of the people, and the supremacy of the law. So everything we are doing in Tunisia is trying to find the balance between the two laws, between the two articles. Article 1, which says that Tunisia is a country or a republic whose religion is Islam, and then Article 2, which says Tunisia is a civil state based on citizenship. So finding that balance without becoming a theocratic state, without giving the religious leaders a veto power on what is Islam or what kind of laws we are allowed to have. The imams and the religious scholars, they still have a very important role to play, which is to guide the population, to guide the people, and including the politicians, on what Islam says and what they think Islam requires. However, their opinions are not binding, and their opinions are only advice to the politicians. The politicians then they have to vote in parliament, and the people will hold the politicians accountable if they don't feel that the politicians respected the constitution or respected the religion of the majority of the people of Tunisia. So it is a very challenging time because we are trying to bridge the gap between these conservative forces and modern secular forces. We are trying to build a modern democracy in an Arab and Muslim country. So far we are succeeding, but there are still many, many challenges that remain. Thank you, and I hope that I've answered all your questions. If you have any more questions, I'm happy to take them.
Hello, everyone. Okay, I'm gonna try to keep my comments very short. The most interesting work on reform in the area of family law is in fact going on in Tunisia and Morocco right now, because also they are the least despotic or authoritarian governments, comparatively, of course, in the Arab world. There is a direct proportional relationship between the legacy of how deeply the legacy of law is and the dynamics of democracy and authoritarianism rather. Whenever we talk about law and legal interpretation and legal reform, it is always useful to differentiate between three levels of analysis. And this applies in the case of Islamic law, and it applies in the case of many other legal systems. There are the mechanics of legal reform, the mechanics of legal interpretation. There are the dynamics of legal reform, and finally the politics of legal reform. And this in the field of comparative law is very broad. It's very broadly held and maintained. First, the mechanics. The mechanics have to do with how legal reform takes place. The dynamics of legal reform have to do with who brings about the reform. And the politics of legal reform often have to do with the why of what takes place. So first, the mechanics of legal reform. Legal interpretation. In all legal systems that have existed, that are embedded in history, without exception, legal systems with a historical legacy formed in patriarchal societies. This is not just in the case of Islamic law, but also in the case of Jewish law, and in the case of the old canon law before it was, especially the personal law provisions were repealed. In the case of the common law, deeply patriarchal as well. Secular common law in the area of family law is a complete mess if you haven't had the pleasure of working in that field, but it's completely chaotic, as any of you have ever had the experience of going to divorce court or had a custody case will attest to. It's an absolute mess. But anyway, the mechanics of legal interpretation has to do with the way that legal experts negotiate the text of law in order to reach desired results. And in my view, that's not where most of the challenge is. A good legal mind can interpret things within a wide, broad array of meanings. And often the tension is between literalists and non-literalists. But again, that goes back to the mechanics. I don't think when it comes to Islamic legal reform that the mechanics of legal interpretation are the challenge. Perhaps sometimes the level of education is a challenge, but nevertheless, a gifted legal mind can negotiate the mechanics of legal interpretations in a variety of ways. Then let's take the dynamics of legal interpretation, the who. Now, the who does the legal interpretation, does pose a challenge in many Muslim countries. Because since colonialism, there has been a distinct classes and tension between a class of urban, Western-educated, Westernized, tends to be middle class towards high middle class group of social actors that often exist with different levels of tension with people who haven't traveled outside the countries, who do not master a language other than the native language, people from rural areas, and that has consistently posed a tension in working through legal reform in the modern Muslim world. And here is in fact where democracy and the empowerment and the vetting out of social problems become quite necessary, because authoritarianism and despotism simply impose change from the top bottom, but it doesn't convince anyone. In fact, what has happened in the Muslim world is that the more authoritarian and despotic the system of government, the more the elite tries to change from the top, the more the bottom resists and the more conservative the bottom becomes. When people feel that a dictator is trying to shove reform down their throat, it is natural that they only resist in every way they can, even if simply psychologically, and to reject reform not because they don't like the reform, but because it's coming from the dictator. A good example today would be Egypt, which has probably the worst dictatorship it has witnessed in the past 60 years. The area of family law, while the elite, which is allied with the military, is in a brutal and inhumane dictatorship under the regime of Sisi. And the more the brutality of that regime has increased, the more resistance to reform at the religious and the rural and the popular level has grown. In fact, the more there has been regression to frames of and mindsets that we thought were transcended and that people had gone beyond. One very simple example are discussions today about talaq laws or divorce laws. At the popular level, all ideas of reform are closely tied to the idea of the dictatorship that is supported by the West and Saudi Arabia and the United Arab Emirates and Israel, and associating the ideas of reforms with the dictators and their allies. In this regard, I don't think it's an accident that some of the most interesting ideas for reform are coming out of Tunisia and Turkey and Morocco, which is a special case because it has a mixed human rights record, but compared to countries like Egypt, it is of course, and compared to countries like Saudi Arabia, it is 100 times better. Okay. Finally, let's take the politics of interpretation. Now, the politics of reform is the bottom line of why is it that we are seeking reform. There is a material difference between reform, for instance, on issues of gender, which is animated and given power to or empowered by, whoa. I thought I'm falling over. Twilight moment. Okay. Change that is empowered by social demand as opposed to change that seeks to placate a powerhouse or a power source. So, for instance, there's a difference between a demand for equality in inheritance that is given effect to or empowered by women who endure a consistent and persistent social problem and translate that social problem into a demand from reform from the inside, as opposed to reform that is brought about in order to appease a colonizing power like in the old days, Britain, where many changes in family law were made in order to appease a colonial power, or today in order to appease the United States, or in the case of, for instance, Saudi Arabia and a lot of the changes made by MBS, Mohammed bin Salman, in order to improve his reputation or his image in the West. It is not a surprise that legal reform, when it is put in place in order to placate and appease external forces, tends to backfire. And that has consistently happened in the Muslim world, again and again, where people from the top institute reform, but not because there's a demand for reform from within society, but primarily to address the outside world, to get brownie points with the international world, or usually the West, usually particular powers in the West. And as a result, it's not surprising that the reaction to that is greater conservatism, greater literalism, greater traditionalism, greater fundamentalism, and even greater fanaticism. Get used to thinking, when the minute you think about legal change, the mechanics, the dynamics, and the politics. And as you break down the analysis in terms of these three prongs, you can shed a much greater level of sophistication in understanding why something happens in law, or why it doesn't, or why it meets a lot of resistance. Okay, thank you.
I'm curious about your opinions about the role of economics in terms of changing people's attitudes towards gender and family law more broadly. So on the one hand, there's the argument that as there's a stronger middle class, people adopt more progressive values. And we saw this kind of in terms of the changing dynamic of Moroccan family structure. But on the other hand, you mentioned, for example, the 20% of households which are solely run by women, and this issue of really material grievances of poverty that might spur some sort of change because they feel aggrieved by unequal inheritance, for example. How do those two sort of seemingly different economic forces affect the way that people view family law and specifically issues of inheritance?
Okay. If I understand correctly your question, actually, I can stand up. I feel more comfortable talking this way. The first part of your question, you're talking about the economic. I did not get it very well.
I mean, like the idea that when you, so people explain why is Tunisia progressive, more progressive than the other Arab states, and one possible explanation is it's richer and has a stronger middle class.
Okay, that's your point. Okay, actually, I did not perhaps mention it very clearly, but this kind of request is really coming, as far as Morocco is concerned, and the Moroccan society, the request on reviewing or reforming these laws, among other laws, the laws on inheritance, they come from the grassroots, because the suffering of people and the feeling of something unfair going on there. And that's, in that regard, the 20% of households in Morocco led by women or supported by women, financially speaking, is just a way to show that these women who are actually supporting a family already with no man in charge with them, and they support their parents most of the time, the parents who are still alive, and they are often working for the parents to sustain the parents and the children. So in this case, when you think of it, the example of Tasib, since I mentioned the Tasib as a priority, it's so unfair for that kind of Moroccan category. That's why they're speaking up. Actually, they're not even speaking up for themselves in a direct way, because they don't have the tools to do it because of poverty and precarity. But NGOs and people who reach out to these women actually convey their messages through NGOs. NGOs are doing a major work in Morocco. NGOs in Morocco are very active. They are actually diverse, by the way. I mentioned that because it's a polarized society. And you have NGOs which are really, I wouldn't say secular, but very liberal and looking for really gender equality in the sense that we know it also in the Western world. And you have also NGOs who are really working more on a more traditional conservative way, but still advocating for change in the advantage of women. So all this to say that this is just an example to give you that there's an argument or a background for this coming from the grassroots to change things in terms of ta'asib, because these ladies, at the end of the day, are, if they are, let's say, they don't have any brother, and they are siblings, only girls, and one of the parents pass away, and even the worst part is the house when it's owned by one of the parents, and one of the parents passes away, and these women can not inherit or share their inheritance between sisters. They need to call for an uncle coming sometimes from remote places, people whom they never met, or cousins when there is no uncle. so remote relatives come and split the shares with these girls, and when it concerns a home or something related to real estate, they actually get kicked out of the house because the law is really authorizing all the heirs to actually split. I mean, they have to sell this home, this house, and split the result of this operation, this financial operation. So that's really so unfair, and it's a violence in a way. It's a terrible violence which is experienced by these women. So really, it comes from the grassroots in that case, and it's very interesting to listen to Dr. Abou El Fadl about the idea of the despotic governments in the Arab world, etc. When the laws, the progressive laws, come from, it's a top-down movement. Of course, this is something that is not basically coming from the grassroots. It's the other way around. But we can notice, and clearly notice, in the last years, the last decade and a bit more, and some reforms which took place in a country like Morocco did come from the grassroots, and which makes them be even more impactful and powerful and enforced more easily than a law or a reform coming on a top-down perspective.
How do these family laws, like both past, present, and those being reformed currently, affect the non-Muslim Arab population, meaning the minorities such as like Coptic Christians, other Christians, Jews, etc.?
I
So,
just
just repeat the question, if you don't mind. I think for either of you. But the question is about how these reforms specifically, right, affected non-Muslim populations.
Let me, you might want to talk about Jews in Morocco, but Jews and Christians in a country like Egypt, and I think in all countries that maintain a confessional system within family law, family law or personal law applies by religious status. So Muslims have their own Muslim family law, Christians have, in a country like Egypt, Coptic family law, and Jews have rabbinic Jewish law of Egyptian interpretations. So it's not even the rabbis in Jerusalem, for instance, but it's the rabbis in Egypt. One of the very interesting things is that not just Muslim, but confessional religious systems have, in a country like Egypt, the Coptic Church has actually been one of the main sources of resistance for reform in family law, because there are certain monopolies that the Coptic Church has over marriage and divorce and custody, and the Coptic Church in Egypt, the same thing in countries where you have minorities that control a certain parochial religious system and legal system. The Coptic Church fears losing or having to share its power over Christian religious law with either the Protestant Church or the Catholic non-Coptic Church in Egypt. So they have till now managed to work out with the government nearly an exclusive deal over all affairs relating to family and personal law having to do with Christians in Egypt, which actually results in quite a great deal of unfairness when it comes to Christians who are not Copts. But the Coptic Church has also been one of the very close allies to the Sisi regime, because dictatorship works well for them. They can stem off secular reforms, and they can also stem off changes in personal law that would take away their privileged position. Politics is always far more complex than ideology, and all the stereotypes that people repeat about Islam this and Christian this and whatever, when it comes to the realities on the ground, are a bunch of nonsense, as the Egyptian case demonstrates. Do you want to talk about
Actually
Tunisia?
did not, yeah, just very shortly, your question regarding Morocco and reforms which took place in Morocco with regards to the family code actually did not directly impact the Jewish community in Morocco, since the text itself is not applying to Jews, to Moroccan Jews. They have their own family law applying to them.
Thanks. The civil code in Lebanon, because I'm familiar with it, I'm from Lebanese heritage, doesn't allow a Muslim man to marry a Christian woman, for instance. And to avoid this, many couples who wish to marry from different religion have to leave the country, to go to Cyprus, for instance, to get married and to be recognized as a wife. I wish I could ask the professor from Tunisia about this question, but he's not with us. But I wanted to ask you, in Morocco, is there any form where is this allowed, or is there any reform to it?
I'm happy to answer that, especially that interfaith marriage is also actually an issue in the family law. I say why I'm using the term issue. The number of Moroccan women, Muslim Moroccan women, marrying non-Muslims is really, again, increasing. And the problem is that the law, family law, the Mudawana in Morocco, does not allow Muslim women, Muslim or Moroccan women, to marry actually a non-Muslim. They can marry a non-Moroccan, provided he is a Muslim, but they cannot marry a non-Muslim unless he converts to Islam first. Then the procedure of marriage can take place exactly as if two Moroccan Muslims were getting married actually in Morocco, on the Moroccan territory. The opposite situation, which is actually a Moroccan Muslim man, is allowed by the law, by the Mudawana, to marry any a woman from any of the religions of the book, and she does not have to convert to Islam first. So that's the rule. That's the law as it is in Morocco in the Mudawana at place. And in that regard, and of course, the argument toward that is again of religious nature, as it is said or explained or exposed to people that way, that it comes from Quran, so that's it. But however, and its interesting part is that increasingly, and we can hear them and read and see in Morocco, Islamic scholars and people who work on Islam and on the religious texts who are saying that the background of this law is not Quranic, because Quran is actually banning or forbidding marriages to polytheists, mushrikeen. Okay? So it's again a discussion and a debate, and you can it's a lot of lots of debates are taking place, as you can see. And the problem is what happens to Moroccan women, Muslim Moroccan women who marry a non-Muslim who does not convert. What do we do? What do they do? Well, they don't marry in Morocco, on the Moroccan territory. They go abroad, as you said, and they marry in the country. That's usually how it happens. They marry in the country of origin of the husband.
I wanted to thank the speakers for just having the comment. I happen to know that Tunisia listed in the ban, so Muslim women are allowed in Tunisia to marry
think it's recent. It's very
Yes.
recent.
It's the first
Yes,
country
that's
that
a
raised
new
it.
law. They did that.
Any other questions? Yes.
I just have a question in terms of Morocco. In terms of the support for, or the number of statistics you gave us about women working, is that more in, because I don't, forgive my ignorance, I don't know the makeup of Morocco, how much is urban, how much is rural. Is more of support in the urban areas versus the rural areas? If you can comment on
Oh,
that.
I don't have the number on rural versus urban, but what I can tell you is that this phenomenon is actually taking place everywhere. Women in urban areas are really in charge of households alone, and the number 20% is changing every year slightly. The trend is an increase, a really dramatic increase. And in rural areas, people who know Morocco or are familiar with the Maghreb countries would know how hard workers women are in the rural areas in Morocco. I mean, they are in charge in a way, in the sense that if they are widowed or they don't have, I mean, they are not married, etc., they really work on the land and they are supporting a family as well. So the phenomenon, I think, is split in both areas, but I cannot give you just the number, the exact statistics. So.
Okay. This is just based on like your personal travels around?
It's actually clearly the field work that I do all the time as I live and work in Morocco, and you can see that when you do field work. I mean, women are in charge in both situations. I would say, again, I'll check on the statistics to see, out of curiosity, you raised my curiosity on that, but I would say it's more in the urban areas that they are in charge, rather than more than rural areas. Yeah.
Both the rural and urban go through the same educational system?
Yes, it's the same educational system everywhere. The state educational system is the same. It's common to the whole country.
If I could exercise moderator's prerogative and just ask one final question to Professor Abou El Fadl. You raised a very interesting point about, sort of the top-down reform versus grassroots reform. So, I mean, my question basically has to do with the potential for grassroots reform in these profoundly entrenched dictatorships. So, I mean, let's talk about Egypt and Saudi Arabia, for example. Now, in the case of Saudi Arabia, of course, we had that wonderfully liberating, what was it, sort of lifting of the ban on women's driving, right? Which is extraordinary to me that in this day and age we can still talk about that as being liberating, but there you have it. But that is a top-down reform. And I can see how something like that may have been resisted, but it is a practical and important step. So, I mean, in these contexts, do you see any scope for grassroots reform of this very practical nature that, you think might catch on? Or do we just have to wait for democracies in all of these places?
No, I mean, we don't. I mean, part of the part of the issue is how did we get the ban on Muslim on women driving in the first place in a place like Saudi Arabia, which I believe again arose from a very dictatorial process that was artificial. So, am I in favor of in a situation like this of a ruler saying, "Well, women can drive"? Yes, I am, but at the same time, I am very worried about what type of backfire you could get in the longer term. I mean, since colonialism, now it's been, 60 years or more, and the entire region has been locked in this dynamic of dictatorship and a counter-reaction of profound reactionism in response to dictatorship. And I don't see a way out between this one polarized position against another polarized position, except for democracy in the longer term. And without it, I think the region is just going to remain swinging back and forth between a benevolent or not so benevolent, or a murderous, crazy, benevolent ruler like MBS, who institutes reform and then responded to by some type of reactionary religious fundamentalism. And there doesn't seem to be a way forward except some form of democracy, a la Tunisian model, Moroccan model, Turkish model.
Well, thank you both for your thoughts and insights, and thank you all for coming out on a weekday evening. This was, I think, a wonderful panel, and I hope you all benefited. So let's thank our speakers.